Robert Rubenstein is a partner in the law firm of Gaylord, Rubenstein and Pop, with offices in Ewing Township. He has been designated by our Supreme Court as a certified civil trial attorney. In addition, Bob has special expertise in motor vehicle accident, personal injury cases, and insurance law. Carl Friedrichs is also an experienced personal injury attorney who, along with Bob Rubenstein, has written the book New Jersey Motor Vehicle Law and Practice Forms, published by Thomson West. Let's join our host, attorney and author Robert Ramsey, as he discusses these important issues with our guests.
Bob, let's get started with you. Take a situation where you have a young attorney who begins his interview with a client on a personal injury case as a result of a motor vehicle accident. What generally would you recommend that the attorney cover right off the bat with the client?
Well, typically I think it's important to explain to the client what the process entails. Let them know what to expect during the entire process. And generally I do it in this fashion. I explain to them, and I'll just go through as though I'm actually speaking to them. There are 4 different things that happen when somebody's involved in an automobile accident. Many of those things are things that can be handled by the individual themselves. But for instance, the first thing that happens is typically there's damage to a car, the person's car themselves. And it's important at that point to explain to the client how they go about getting the property damage taken care of. It's generally not something that the attorneys get that involved in. It's usually the individual themselves talking to either their insurance company or the other driver's insurance company. From my perspective, it's always easier for the client to speak through their own insurance company. But it's important to explain to the client that when they go through their own insurance company, they have a deductible, typically a $500 deductible. If the accident is in fact the other driver's fault, they will get their deductible back at some point in time because their insurance company will arbitrate the matter with the other driver's insurance company. Usually it's about 6 months down the road if it's something that's clear cut. If it's not clear cut, it may take longer and they might not get their whole deductible back. Their other option, if they can't afford to be without that $500 deductible, is to go through the other driver's insurance company. The difference is, when you go through the other driver's insurance company, there is the ability of that insurance company to argue fault. They have the ability to say, well, we think you stopped short, so we're going to attribute 10% of the value of the car to you. It happens sometimes with certain insurance companies in New Jersey. So it's important to explain to the client how that process works. And then we always offer that we're willing to help them out if they need. For instance, we can give them a website that will help them learn what the value of their car is. Our office typically uses Edmunds as the guideline, edmunds.com, and they can plug in the information about their particular car and learn whether or not the insurance company is giving them a fair analysis and valuation of the car. That's if the car is a total loss. But it's important to explain to them how that process works to put them at ease and let them understand what's going to happen. Because the most important part with a client is when they first come to us, they know nothing. They don't know anything about what to expect. So it's important to let them know that. So the first thing that happens in an accident, when there's an automobile accident, is the property damage to the car. The second thing that happens that not everybody really addresses with the client at the outset, but I think is very important, is the fact that there's generally somebody's given a ticket. There's a motor vehicle summons that's issued. In New Jersey, if somebody is injured in the accident, the officer is supposed to check that off on the summons itself. Right. And generally that will cause the municipal court to issue a notice for your client to show up in court. We don't want our clients testifying in municipal court. Anything they say there is the first time that they're going to be under oath creating a record as to what's happened.
Either as a defendant or as a witness.
Correct. And as a witness, hopefully they're not there as a defendant, and we'll talk about screening cases later on, but as a witness/victim, we don't want them even answering questions from the judge, were you hurt or what was hurt, or certainly from a defense attorney during a trial or the prosecutor. So our objective early on is to explain to them what the municipal court process is about. Now, most attorneys who handle personal injury cases don't go to court with their client as a victim. The clients don't understand that, and the clients are very intimidated by the process. And one of the reasons why they come to an attorney is because they don't understand all of that. So in our office, one of the things we do that I think is very important for an attorney to do early on is to explain what that municipal court process is about, and more importantly, explain to them why they don't have to be concerned with what happens in that court. For instance, explaining to them that the defendant could plead guilty with a civil reservation, meaning that nothing that happens in municipal court is going to be admissible in their lawsuit anyway, or that the prosecutor may downgrade it to a lesser offense, a no-point ticket. And a lot of times the client doesn't understand that and thinks there has to be a conviction and a guilty plea or their case is lost.
Right.
So I early on try to explain to them, right at the very first time I meet with them, that I'm not going to go to court with them unless, I always offer that if they're overly anxious or it's a client that really needs to have their hand held, I'll go down there with them. But I like to sort of program the client, so to speak, ahead of time that they don't need to worry about that.
What else do you try to get the clients ready for initially?
The third thing is the medical bills. And that's the third thing that happens in an automobile accident. First you have your property damage, then the municipal court, and the third thing is the medical bills. Because that's one of the main reasons they come to our office, is they're anxious about who's going to take care of their medical bills, who's going to get them the medical treatment. So one of the things we do to assist in that is to tell the clients and explain how New Jersey law works. New Jersey's a no-fault state. And we explain to the client, no fault means just that. And what it means is that your own auto insurance company is responsible for paying your medical bills regardless of who's at fault. That's the critical piece of New Jersey law. I always like to also explain to them that New Jersey is one of 12 states that does it this way. It's not the best system there is, but that's how it is in New Jersey, and that's what we're stuck with. So because of that, they're very upset about that. It's very hard for somebody who has been in an automobile accident where they've been crashed into by somebody else who was careless or perhaps drunk, and their own insurance company has to pay their medical bills. And they're very upset about that. So it's real important to explain to them at the outset that
That may be the only money they're going to get.
right, well, but that's the law in New Jersey,
Right.
and they're stuck with it. And I explain to them what's going to happen in the process, that the first step in all of it is they need to notify their insurance company, if they haven't, or we will, that they've been injured in the accident, and the insurance company will then send what's called a personal injury protection application. They have to fill that application out. Again, I like to have them do that in my office. When I meet with them, I have my own ready to go,
Right.
to have them sign. We send that to their insurance company, and we explain to them they're going to have a $250 deductible on a typical policy, a $250 deductible, and a 20% copayment up to the first $5,000 worth of medical expenses. And their insurance company then pays at 100% after that. So that's how the process works. It's important to explain to the client that the copay and deductible, if they have health insurance, they should submit it to the health insurance. It may or may not pay, but it's important to do that as a next step in the process. I always like to also let them know that the insurance company is not in the business of paying doctors. They don't like to do that, so that they can expect that during the course of this, there will be some difficulties in that process.